Namaste, one and all. I am Sri Jampani, founder of Egna Legal. Together with P. Bhaskar, my brother, founder of Egna Legal, I welcome you all and I welcome Avadhani Garu to this today's lecture. I request P. Bhaskar Garu to introduce today's distinguished speaker, Avadhani Garu.
It's a privilege to introduce Sri VSR Avadhani, a academician par excellence and a judicial officer who has proved to be most capable. And I have privilege to appear before him. I'll share it on a different occasion. Today, Sri VSR Avadhani is a gold medalist in law from Andhra University, and he started his practice and proved himself to be very successful as a civil lawyer, and was selected to the judiciary in 1987, and subsequently was also promoted as district judge, super time scale, and worked as director AP Judicial Academy, registrar judicial of Supreme Court, and subsequently selected as Secretary General of the Supreme Court in the cadre of the Judge of the High Court and Secretary to the Government of India. In that capacity, he was instrumental in bringing several reforms in the Supreme Court registry. He included he introduced the e-cause list and also the digitalization of all the records from 1947 to 1991. And he was also in charge of Supreme Court records, Supreme Court reports and official law journal. And he raised the capacity, the subscription from 55 to 3,000 during his tenure as the Secretary General, Supreme Court. He also participated in several conferences as delegate from the Indian government and judiciary representing the Supreme Court, and he was a guest faculty to several state judicial academies, National Academy, and several police academies. He is a visiting faculty of Christ University Law School, Bangalore, and Teaching Evidence Act. He joined as a member of National Law Tribunal, and subsequently he resigned to the judiciary, and he also resigned to the post of the judicial member, National Company Law Tribunal, and incorporated Avadhani and Associates, a law firm, and he is today the senior partner and senior consultant of the law firm. As a legal, he is also a legal advisor to several corporate bodies and banks, and is acting as arbitrator in several matters. And he did not lose his academic zeal to say, because he has authored several books and they are well received by the legal fraternity. And his regular weekly column, La Lochanam Andhra Jyoti, Telugu Daily, is very popular, and he is the chief editor of Supreme Court Journal. Sir, with this, I request you, sir, to kindly address the webinar.
Thank you, Mr. Bhaskar and Mrs. Sridevi, for giving an opportunity for me to share this platform with young and seasoned generation of lawyers and other professionals relating to law. Several things were said about me, but I am still have the privilege of interacting with you as a student of law, but not in any other capacity. I think my voice is audible.
Yes, sir.
And a subject which is interested to me is to share this platform on the dynamics of the pleadings. Pleadings, as most of you are aware, is the basic foundation of any litigation between the litigant and the judicial forum, maybe a civil court, maybe an arbitral tribunal, or other kind of statutory tribunal. The pleading serves as a connecting or accessing agent for the client to reach the judicial system. Therefore, pleading is the gateway of the litigation. As you are aware, that pleading is the basic foundation for the entire structure of the litigation. I need not overstate or emphasize about the importance of pleadings, except borrowing what the learned and celebrated jurist Jacob has defined it. To open this interaction, I would like to quote Jacob in his own words. Pleadings do not only define the issues between the parties for the final decision of the court at the trial, they manifest and exert their importance throughout the whole process of the litigation. They show on their face whether a reasonable cause of action or defense is disclosed. They provide a guide for the proper mode of trial, and particularly for the trial of preliminary issues of law or fact. They demonstrate upon which party the burden of proof lies and who has the right to open the issue. They act as a measure for comparing the evidence of a party with the case which he has pleaded. They determine the range of the admissible evidence, and the party should be prepared to adduce at the trial. They delimit the relief which the court can award. So the function and the operation as well as the scope of the pleadings is well defined by the jurist Jacob. I quote, Jacob, the present importance of pleadings, published in Current Legal Problems by Harvard Law School in 1960. The same principles referred by Jacob have been reiterated by Supreme Court as well as several high courts in course of time. From 1960 till now, the pleadings have been given most basic importance in the civil litigation. Then, what is the law? What is the practice? And what is the best practices we can share and develop or improve the well-settled practices for the further cause of the civil litigation is the question to be interacted on this platform. It is significant to state that the law of pleadings is codified. Codified in the sense Civil Procedure Code is the text and the spirit of the entire law of pleadings for the purpose of civil litigation in the civil courts. Almost in arbitral tribunals, debt recovery tribunal, National Company Law Tribunal, or other statutory tribunals like Green Tribunal, also the same principles of evidence, same principles of civil procedure, so far as the procedure and pleadings are concerned, is being adopted and followed authoritatively. In this regard, I would like to say, in common parlance, pleading is the prayer. The anatomy of the pleading is, pleading includes only plaint and written statement. For the purpose of pleading under Civil Procedure Code, only the plaint and the written statement is the pleading. There are several confusive statements from different high courts, whether a rejoinder is a pleading, whether the annexes to the plaint are also amount to pleading or not. We will discuss about those legal issues on some other occasion. But basically, plaint and the written statement alone are the pleadings for the purpose of our discussion within the four corners of the Order 6. Then, what is the anatomy? What is the anatomy of plaint? Plaint is divided into several parts. The main parts, core parts are long cause title, short cause title. Description of the parties is the long cause title. Short cause title indicates the place of the court and the position of the parties, who is the plaintiff and who is the defendant. The second is long cause title, description of parties and address for service of summons and proceedings on the parties. Third is brief facts of the case, that is the claim. The fourth is cause of action. Then court fees, valuation for the purpose of court fees, and the jurisdiction, pecuniary limits of the court. and then relief prayed for. In between these main elements of the total anatomy and structure of the plaint, some developments are there. These developments are on account of various circular instructions of the high courts. One is the cause of action is divided into pecuniary cause of action and territorial cause of action to show that a cause of action arose within the territorial jurisdiction and the cause of action for the purpose of valuation jurisdiction. It is subdivided. Then another subpara is also included according to the circular instructions of various high courts, including High Court of Combined High Court of Andhra Pradesh and Telangana, that the suit is within time. And another subpara is that there was no connected pleading pending proceedings relating to the subject matter of the suit. But basically, only 5 parts are the constituents of the plaint. Then, originally, in the long cause title, the description of the parties are not included. Only plaintiff XYZ, defendant ABC. Now, after 1990, for the purpose of facilitating the office to draft the decree effectively, there was a circular instruction from the High Court and various district courts also that even in the long cause title, short cause title also, the description of the parties should be mentioned. Now we are adopting the present form of the plaint in all these respects. Then comes to the main point, that is prayer. The third part is facts of the claim relating to the plaint, and the last para is relief. In between, there is a cause of action. So the entire purpose of prayer in the third para of the plaint is to guide the court to show that the plaintiff has a right to sue. Right to sue should not be confused with cause of action. I repeat, right to sue is different from the right to have a suit filed and cause of action. I will explain like this. Right to sue indicates the plaintiff's capacity to file the suit. Right to sue indicates the plaintiff's locus standi to file the suit. And the right to sue indicates that there is a right in the plaintiff to claim a relief. So far as the cause of action is concerned, it includes right to sue. Cause of action includes right to sue. I will make it clear. Unless the plaintiff possesses a right to sue, he cannot have a valid cause of action. But cause of action is independent for the purpose of filing the suit, unless the suit should come within the jurisdiction, both pecuniary as well as territorial, of that particular court. Therefore, cause of action should be explained in a way that it should not only indicate the right of the plaintiff to sue, but also should indicate that a particular court chosen by the plaintiff has been empowered to entertain the suit. So in this way, the prayer should reflect the entire gamut of the plaint. The reliefs claimed should be relevant to the facts pleaded in the third column of the plaint. In this way, the plaint should disclose material facts. What are the material facts? And the plaint need not disclose the question of law, question of evidence. We have been in practice seeing that the plaint not only is indicating in practice, not only indicating the facts relating to the right of the plaintiff to sue, but also indicating points of law, and they are citing the decisions also in the plaint, material points of the plaint that should be discarded. I will give one example where law has to be stated, where question of law need not be stated. A suit is based on a promissory note. You should look into the appropriate legal provision relating to a negotiable instrument. A promissory note is liable to be paid on demand. Therefore, there should be a demand. While pleading in the plaintiff says that the defendant has executed promissory note and he did not repay that same. There we have to include, in spite of demands, the defendant has committed default in paying the amount. You need not state that a demand was made as per the provisions of Negotiable Instrument Act so and so, as decided by High Court of Madras so and so. We need not say. When we say that plaintiff has demanded and the defendant did not pay the money, it is in compliance of the legal formalities of a plaintiff. Whether there was a demand legally made, whether the demand is adequate or not, whether that demand is received by the defendant or not, are questions of evidence. So they should be inquired into at the time of trial, and that need not be mentioned in the plaint. Suppose it is a case of will. X has executed a will in favor of the plaintiff, the legatee, bequeathing the property shown in the schedule in favor of the plaintiff. For the purpose of constituting a valid will, it must be shown by the propounder of the will that the testator was in sound and disposing state of mind. It is a condition precedent while the provisions of Section 73 of the Indian Succession Act. It must be shown that there are attesting witnesses who have witnessed the propositors executing and signing the document in their presence. At the same time, there is another condition also, that the executor of the will has seen the attestors attesting the will in her or in his presence. These are the conditions precedent to establish that there was a valid will executed by the deceased. So the plaint must contain as a condition precedent that the XYZ has executed her last will and testament in sound disposing state of mind, and it was properly and duly attested. It is sufficient. If the will is shown and pleaded that it is properly attested, we need not say that it is attested by two witnesses in her presence and she has seen the attestors executing the witnesses, and there is a compliance of the provisions of Indian Evidence Act as well as Indian Succession Act. We need not state. This is sufficient. Suppose a widow is claiming that her rights in the property have been enlarged by operation of Section 14 of the Hindu Succession Act. If the plaint contains that, what is the condition precedent? The widow must be in possession of the property on or after the promulgation of Section 14 of the Hindu Succession Act. Therefore, the plaint must contain that the property was given to the plaintiff, the widow, by her husband in recognition of her pre-existing right, one. And secondly, from the date of that gift or giving that share in partition to her to be enjoyed by lifetime, she has been in continuous possession in her own right, and her rights are enlarged. That's all. We need not say that it is enlarged under Section 14. We need not say that she is enjoying that property in her own right. Her rights are enlarged means there is a compliance of Section 14. These are the cases where we need not state the law. But there are still cases where we have to state the legal provision. Suppose Section 6 is there. Section 6 of the Hindu Succession Act is substituted after the amendment in 2005. Now there is a confusion whether a daughter who is born on or after 2005 or a person who was alive prior to 2005 at the time of partition but died thereafter, whether the daughter can claim as a co-partner, claiming equal right to that of a son or not is a confusion. Of course, recently the larger bench of the Supreme Court, 3 judges bench of the Supreme Court settled that a daughter who is born in a Hindu joint family would get right a share equal to that of a son, even retrospectively. That means the substituted provision of section 6 has retrospective in operation. That is the law. So before this law is settled by the Supreme Court, we need to mention in the plain that she was not given any share. The brothers have divided the share, but her rights are conferred as a co-partner. Therefore, the partition affected without her presence being taken part in the partition. Her right is not settled, and therefore she is entitled for right by virtue of section 6, etc. We have to mention, because the law was in a fluid stage at that time. Similarly, where a partition was affected and a share was given, but it is unequal share, or a partition was not affected, but the manager, Karta of the family, has sold away the property for avyavaharika debt, a special plea has to be made in the plain that the debts are tainted with illegality. The debts are not binding on me. The partition affected on so and so date is unequal partition, etc. So the facts have to be specifically pleaded with the dates. So the pleading shall be categorized in two ways. One is general pleading and a special pleading. What all the examples I have cited now are in the category of special pleadings. What is the general pleading? General pleading does not emphasize on any special circumstance. A suit for partition by the son against the other brothers and father. It did not say any special circumstance, except saying that the property was joint. If there is a confusion about the question whether property was joint or not, the son has to plead that the property was acquired by great-grandfather and had been enjoyed as a joint family property, and I have a vested right in the property. So it does not require any special pleading except to show that it is a joint family property and to show that he has an undivided share in the property. Where special pleading is required, only when there is an alienation. To impugn that legality of that alienation, we have to say that it is avyavaharika debt. Where a transaction is affected by fraud or misrepresentation or coercion, a special pleading is necessary. So, pleading in that sense, whether it is a general pleading or special pleading, as far as possible, it should be clear. It should not be ambiguous statement of facts. It should not create any confusion in the mind of the other party. In fact, a plaint is a replica of what had been occurred past. So we are reenacting what had been occurred in the past. We are reenacting the stage, we are placing on the stage the events that were occurred in the past, about execution of a will, about execution of a deed, about execution of a promissory note. All have been happened prior to the drafting of plaint, but given rise to a cause of action. Therefore, we are driving the court to look into what had happened in the past and what made me to institute the suit. So we have to take the court and other party to travel throughout a timeline, right from the inception of the legal right till the cause of action that prompted the plaintiff to approach the court. So throughout this timeline, There should not be any sidelines. We should take the court directly to the point. Therefore, the plaint should be very simple, in a simple way, in a simple language, and it should be as simple as possible. In a synoptic way, the plaint has to be drafted. It is settled law that plaintiff is not an art of literature. We should not use phrases. We should not use idioms in the plaint. In some plaint I have seen, by drawing the amount, it is to the shock and surprise. The plaintiff thought a bolt has fallen from the blue. These type of idioms or phrases should not be used in the plaint. You should not show your art of literature, your capacity to prepare an article of literature in the plaint. Likewise, written statement also, point to point. You should facilitate the court to grasp what is in your mind, what is in the mind of the plaintiff, and what is in the mind of the written statement, in the mind of the defendant, so that it can frame the issues appropriately. Now, framing of issues has become a very critical subject in the practice. I will come to that aspect on some other occasion. But so far as the plaint is concerned, I will give some examples, few examples relating to the plaint. Technicalities should not hinder the true appreciation of the language employed in the plaint. The court or the defendant has to interpret the plaint as it is. There should not be any creation of confusion in the minds of the other stakeholder. How many stakeholders are in the civil litigation? Plaintiff, plaintiff's counsel, defendant, defendant's counsel, and the main player is the plaintiff's counsel. Because at your instance only, the entire saga of litigation has commenced its voyage. Therefore, the plaintiff's advocate should play an important role in the continuous journey of the litigation, right from the municipal court, junior civil judges court, to the Supreme Court. Therefore, one of the seniors used to say, even if a suit was lost, he used to say to the client that, no, you have contributed law. Your name will be published in law journals in next generation. In Venkat Subbaya, Tulsimma versus Venkat Subbaya, we do not know who is the judge and we do not know who is the advocate appeared for them, but we know only Tulsimma and Venkat Subbaya. Minerva Mills, we know about Minerva Mills versus Menaka Gandhi. We know Kesavananda Bharati, but we do not know who are the judges, who are the advocates appeared for them. Therefore, it is the party and the plaintiff's counsel who will study the history of the litigation till the end. Keeping this basic principle in mind, we should examine how to draft a plaint and what are the practices developed by our seniors and our contemporaries in this field. This is the introductory part of the today's interaction. I will take you certain provisions of Order 6. What I want to say is, substance is the important in the plaint, but not the language. Substance means, substance is the cause of action, substance relating to the relief, substance relating to the plaintiff's right to sue. This is the introductory part. Then Order 6 is the science of the pleadings. Pleading shall mean, as we have referred earlier, plaint shall mean, pleading shall mean plaint or written statement. Why they have used or? Plaintiff and written statement. Pleadings shall mean plaint and written statement. But the legislature has used plaint or written statement. Is there any significance by using or instead of and? I need some comment from the participant side. Do you find any significance in employing the expression or instead of and? There I want to emphasize, plaint includes a rejoinder. Plaint includes several annexes like plan, like genealogy table, etc. Likewise, written statement includes additional written statement, etc. Plaint or written statement, why they might have used is, sometimes a written statement would attain the character of a plaint. May I quote an example? In a suit for partition, all the plaintiffs have to be treated as defendants. Similarly, all the defendants have to be regarded as plaintiffs. Suppose the plaintiff withdraw the suit, the written statement will attain the character of a plaint, and the party in the treat his written statement as a plaint for the purpose of a suit for partition. Similarly, where there are certain defendants who are sailing with the plaintiff, we say in common language, collusive defendants. Those defendants who are sailing with the plaintiff. Suppose plaintiff withdraw from the war. He withdraws from the litigation. Then the defendants who are sailing with him may feel that their rights are under jeopardy. So they may come and transpose themselves under Order Rule 1, Rule 10 as the plaintiffs. At that time, they might have already filed a written statement admitting the plaintiff's claim, and this will become part of the plaint, and they will attain the character of the plaint. They may claim for amendment of the written statement to add some elements to show that it is a plaint. Therefore, because there are chances that a written statement may also be regarded as a plaint, the legislature has used the word or instead of and. This is my view. And the Order 1, Rule 1, while defining the Order 6, Rule 1, while defining the pleading, takes us to the next attribute of a plaint, that is, pleading to state material fact and not evidence. The subtitle of this rule is pleading to state material facts. Why they have not limited this title to facts? Does it mean that there are material facts and immaterial facts? Does it mean that only those facts which appear to be material in the view of the plaintiff alone should be stated, leaving the facts which may be material to the defendant? Or in other words, only the facts which are material in my perception alone has to be stated in the plaint, leaving alone the facts which are material from the perception and perspective of the defendant. Material fact is not defined anywhere in the Civil Procedure Code. So there are legal precedents to show that material fact should be understood. A fact which is giving rise to a cause of action for the plaintiff. to exercise his right to sue. I will repeat. Material fact is a fact which entitles the plaintiff to raise his cause of action so that he can exercise his right to sue against the defendant. This is the material fact. I think I may not quote the judgments here, but I will take you to a judgment of the Supreme Court. Material facts are referred by various judgments of the Supreme Court as well as High Courts. One of the judgment is Ashwani Kumar Sharma versus Yaduvanshi Singh, 1998, 1 SCC 416. They say that they have taken one example in an election petition. In an election petition under the Representation of People Act, impugning an election, the fact material for the purpose of maintaining the petition is corrupt practice. So, what is a corrupt practice should be specifically stated in the plead. There, the Supreme Court had an occasion to define what is a material fact. There, they have said material fact is a fact giving rise to a cause of action to empower the plaintiff or the petitioner to file the suit. So, this connection has to be built in the plaint itself. And another judgment is Konda Lakshman Bapuji versus Government of Andhra Pradesh, 2002, Volume 3, Supreme Court Cases 258. Sarita versus UP Jilla Adhikar Prescribed Authority, Amethi, 2014, 7, Allahabad. ADJ, Allahabad, Digest of Judgments, 2014, 7, ADJ, 636. All these judgments show what is a material fact for the purpose of Order 6, Rule 2, CPC. Then, every pleading shall contain, they have emphasized in Rule 2, every pleading shall contain and contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. So, by using the words shall contain and contain only, a barrier is placed by the Civil Procedure Code prohibiting the plaintiff or defendant from pleading any facts outside the cause of action, any fact which is irrelevant for the purpose of claiming a right to sue, or any fact which is not material in leading the evidence, and therefore it should contain only the material fact but not the evidence. Then 2 is every pleading shall, when necessary, be divided into paragraphs numbered consecutively, each allegation being, so far as is convenient, contained in a separate paragraph. This is not for the purpose of facilitating us, the plaintiff, draftman of the plaint to understand. It is for us who is defending and for the court who is looking into the plaint to understand what are various allegations or foundations made by the plaintiff to sustain his suit. So every allegation of fraud, for example, should be stated separately. Suppose I will state the defendant has obtained the general power of attorney by making a representation on 1/4/2002, stating that it is for the purpose of submitting an application to the municipal authorities. It is one part of the misrepresentation amounting to fraud. It is continued. Subsequently, in the year 2005, under the pretext of the same general power of attorney, the defendant has obtained a check on so-and-so document, or obtained my signature on so-and-so document. So it is another part of the same cause of action, continuing cause of action. So every act on the part of the defendant pleaded to be a part of fraud should be separately indicated in subparas. A lengthy para should be avoided. By this provision means lengthy drafting of paragraphs should be avoided. From page 2 to page 4, single para, that should be avoided. Then subpara 3, dates, sums and numbers shall be expressed in pleading in figures as well as in words. It is common, we know. Then rule 3 is forms of pleading. The forms of pleading is in appendix 6 wherever it is possible, but it is not possible right now. We have developed some more forms also by practice we are adopting. And rule 4 is particulars to be given where necessary. In many claims, we are seeing that in first para, the suit scheduled property comprised in survey number 140, situated in XYZ village of Mandal of district of state of Telangana, is possessed and enjoyed by the plaintiff. In para 1, para 2, again same, the suit scheduled property, the property that is in survey number so and so, repeating the same. Why you should repeat? In the plaint, para number 1, you have described the property as a plain scheduled property. It is sufficient. In every para, you need not describe the property, except stating the suit property, it is sufficient. So, repeatedly saying that suit scheduled property situated in survey number, in the village, in the mandal, in the panchayat, it is redundant. It is unnecessarily repeating the same words and extending the length of the plaint. That should be avoided. Therefore, particulars to be given where necessary. Only once it may be stated that in earlier proceeding, namely in suit number so and so, hereafter be called as earlier suit. That is sufficient. So in subsequent paras, you may say earlier suit. While referring to a GO, the government issued a GO MS number so and so, department so and so, dated so and so. In one para, and in the brackets you may say, hereafter be called as impugned GO. It is sufficient. So you need not say the same GO number, etc. in the subsequent paras. So wherever necessary, you should state the date and the description of the document and continue the same in a limited form in the subsequent paras. Rule 4, therefore, prescribes that in all cases in which the party pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars have to be furnished. So, date, time, year, once it has to be stated, and the same has to be continued. Then, rule 5, further and better statement of particulars may be provided. Rule 6, condition precedent. This is one important rule. Any condition precedent, the performance of occurrence of which is intended to be contested shall be distinctly specified in the pleading by the plaintiff or defendant. Example, in a suit for specific performance, you should plead specifically that the plaintiff has been ready and willing to perform his part of the contract. Not exactly in the same words, but the substance of the plaint should indicate that the plaintiff has always exhibiting and demonstrating his readiness and willingness to perform his part of the obligations stipulated in the contract. So that is sufficient. So it is a condition precedent that should be stated specifically according to Rule 6. And Rule 8 provides where you are denying a contract, that denial should be specific. When the plaintiff pleads a contract for specific performance and the defendant is denying, there should be a special denial, specific denial. Mere general denial is not sufficient. The plaintiff says the defendant has executed an agreement of sale on so date and received consideration. In the written statement, the defendant denies what are pleaded in para 2 of the plaint in substance. The agreement of sale is not true. That is not sufficient. Why it is not true, you have to state. Whether it is forged, whether your signature was obtained on blank paper, whether no consideration was paid, or whether that was obtained as a guarantee for repayment of certain money under another transaction, contemporary transaction, it should be specifically pleaded. A general denial of contract of sale is not sufficient. And Rule 9, effect of the document has to be stated specifically. Suppose there is a contemporaneous agreement along with the agreement of sale, whereunder it is stated that on so and so date, if the amount is repaid by the defendant vendor, the contract shall stand cancelled. That contemporaneous agreement indicates that the contract executed between the parties will come to an end on the event of a specified event. So this contemporaneous agreement shall be specifically pleaded as an exception to the agreement of sale. In the absence of that special denial, it is deemed that there is admission on the part of the defendant about the enforcement of the agreement. Then, wherever notice is necessary, Rule 11 prescribes that should be stated. A notice on the government is necessary under Section 11. A notice under Section 8(2) of the Insolvency and Bankruptcy Code is mandatory on the part of the corporate creditor, operational creditor. That should be stated with the name, time of delivery, date of delivery should be stated, because from the date of receipt of that notice, 60 days has to be computed for the purpose of Section 80, and 10 days has to be computed for the purpose of Section 8(2) of the IB Code 2016. Therefore, the plaint should indicate the date of service of notice, whether it is a sufficient and adequate service or not, because serving of notice is a condition precedent for the maintainability of this litigation. And Rule 12 provides for implied contract or relation. And presumption of law, Rule 13 and Rule 14, pleading should be decided. Now we will concentrate on 12 and 13. What is implied contract? A contract of agency is created between the parties by implication or by inference. Suppose husband authorized wife to sell the property. She sold away, but she is not given any power of attorney. A brother has authorized another brother to sell the property on his behalf, but there was no written authorization. The plaintiff, Wendy, believed that there was an agency and entered into transaction and filed a suit against wife and husband, or against the brother as well as the brother who has claimed to have been authorized. Suppose there was a payment under a debt by a person who claims to have been authorized by the debtor, where an exemption from limitation under section 18 or 19 is claimed, the Limitation Act is claimed, the authorization is specifically pleaded, and therefore the plaintiff says, the plaintiff should show that there are certain events and circumstances which have compelled the plaintiff to believe that there was an implied agency between the wife and husband, between the brother and brother, and between the debtor and the authorized representative, that made him to enter into a contract. So that implied agency has to be specifically pleaded in the plead. In the absence of that implied agency plea, you cannot enforce the obligation against a non-party to the contract. Then the presumption of law. What is the presumption? A wife and husband are deemed to have authority to give evidence under section 20, 19, 28, 21. There are evidence act sections are there. But that presumption is only to give evidence. A husband is a proper witness to speak to the facts related to the wife. Similarly, wife. So another spouse is authorized to give evidence on behalf of the other spouse without any written authority. But for entering into a contract related to a property, there should be written authorization. There cannot be any presumption. Because in some cases, without written authority, a director used to sell the property. There is no presumption that a director of a company has implied authority to sell the property unless he is authorized either by the articles of association or by a special resolution adopted by the board. So you cannot say that there is a presumption that a wife can execute an agreement of sale on behalf of the husband. Or there is no presumption that a karta of the joint family is authorized to enter into a contract on behalf of the other co-owner in the joint family. Unless there is a, if he is a minor, then we can presume that a karta, being the father, has capacity as a guardian, as a natural guardian of the minor, is executing the document. Other than this, if any legal presumptions are there, you can write that presumption in the law. When there is a dispute between the survey number and extent, what is the presumption? The extent within the boundaries, if it is admitted, the well-settled principle of law is boundaries prevail over the extent. I have purchased 2 acres of the property, but on land, it is shown to have been measured as 2 acres 10 cents. The other party is claiming extra compensation for the 10 cents. I say, no, you sold the property within 4 boundaries. Boundaries prevail over the extent. I need not pay any extra amount to you. So you have to plead that presumption that within these boundaries, I am sold the property in respect of the extent, and therefore I need not pay any extra amount to the vendee. So you have to plead presumption. And every bill or a negotiable instrument signed, but it is a blank document, an inchoate document, a presumption is there. The promisee is entitled to fill gaps under section 20 of the Negotiable Instrument Act, where it is pleaded that only I have issued a blank promissory note to the other party and the blanks are filled by the plaintiff and filed a suit. You can plead that under the presumption laid down under section 20 of the NI Act, I am entitled for a decree. You can write that presumption in the pleading. So this is the procedure related to the pleading, and then I will take you to some examples of material facts. In the case of easements, the material fact is that continuous enjoyment of easement for over a statutory period provided in Section 20 of the Act, for over a period of 20 years and 3 years next before filing of the suit. That should be pleaded specifically. And in a suit for partition, if any alienation is challenged by the minor co-partner after attaining the majority, it must be pleaded that the alienation made by the karta of the joint family is not for the benefit of the joint family, or it is tainted with illegality or immorality. That should be specifically pleaded. Where a contract or transaction is illegal, the illegality should be specifically pleaded. How that is illegal? How the contract is entered into has become illegal. At the time of entering into a contract, it was legal. Subsequently, that has become illegal. Suppose I purchased some property at one point of time when the property belongs to the plaintiff. Subsequently, there was a court decree saying that this property does not belong to the plaintiff. So at the inception, the contract is legal, but subsequently it turned out to be illegal because of happening of some event, that is the decree passed by the court. So you have to plead that the document was enforceable against the defendant at that point of time, but turned to be unenforceable in view of the decree, and therefore I am entitled for refund of money under the contract. Therefore, that specific event that made the contract unenforceable has to be specifically pleaded. Otherwise, you cannot show how you are entitled for refund of consideration. This is related to the contract. We will take a pause here. We have interacted on few provisions of CPC with special reference to Section 6, how a plaint has to contain the substantial pleadings relating to the prayer, besides the introductory part of the plaint. We will take a pause here. I will be happy if anybody raises a question to continue this topic. If anybody is inclined to put a question for continuation of our interaction, kindly raise their hand and share their thoughts. It should not be a one man's approach, like in a commentary, a cricket commentary, or a All India Radio prasangam.
Yeah,
So,
Mr. Rupendra wanted to, I think,
Hello, sir.
raise his hand.
Hello.
hello, Rupendra.
Yes, Mr.
So
Yes,
actually,
Rupendra.
I have 2 acres of land registration on my name when I am minor. Can you hear me, sir?
Yes, 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 sir.
When I am minor, and my grandfather is telling that he didn't cancel the registration. It is made gifted it to me when I am 8 years old. Okay, sir.
Yes, sir. Yes, sir.
Now he is telling that I have sold the land because to spend for your studies, education, and for food. He's saying all those reasons why you are. I asked why you sold my land without any cancellation of my deed.
Yes.
How can I go forward by filing a suit, sir?
Yes. Now, first you have to determine the gift is the facts before you are. The gift was in favor of a minor.
Yes.
The condition precedent for a valid gift is it should be accepted. Section 125 of the Transfer of Property Act says that a gift is operative when once it is accepted. a minor cannot accept the gift. So on your behalf, who was the guardian at that time?
My mother's brother.
So your maternal uncle, plaintiff's prospective plaintiff's maternal uncle was the guardian. So you have to first confirm whether the guardian has accepted the gift on behalf of the minor plaintiff. 2, if the original gift deed is in your custody, there was a settled law having the custody of original gift deed is indication that the gift is accepted, whether it is with you or with your guardian, erstwhile guardian.
It is with me, sir.
It is with you. Therefore, you can confirm that the gift is accepted by your client. Then, once gift is accepted and it is acted upon, the donor cannot revoke the gift. Once the gift is accepted, the donor lost all his rights and he cannot revoke the gift. If he wants to sell the property for the benefit of the minor, it is the minor's separate property. He has to apply under the Guardians and Ward Act for the purpose of selling the property for the benefit of the minor, and a permission has to be granted by the Court and Wards Court under Section 8 of the Guardians and Wards Act, and without that permission, the sale is not binding on you. Thirdly, when you have attained a majority.
Okay. Now I can transfer this land to another one without any problem, sir?
No, because already land was sold. You have not challenged that sale deed. Now, a sale deed can be challenged by you within 3 years after attaining the majority.
Okay.
So you have to confirm whether your suit is within 3 years from the date of your attaining majority. Or you have to plead knowledge. When you are out of possession, how can you say that I came to know about the sale deed today when you are not in possession? If you are already 30 years old, your client is already 30 years old. So that is a problem. Limitation is now a question that has to be taken care of by you. So far as acceptance of gift, vesting the title in you by the donor is confirmed. The only question remains with us, limitation. You cannot escape the limitation law by merely saying that I have no knowledge about the sale deed. Because I am not a party to the sale deed, I need not ask for its cancellation. A cloud is cast on your title long back, and you have to remove that cloud. At least you have to file a suit for declaration of title or declaration that in spite of that sale, you continue to be the owner of the property within 3 years from the date of attaining your majority. So you please take care of that limitation.
Next step, what I have to take now? I couldn't understand. What is mean by majority?
Majority means you are minor till the age of 18 years.
Yes, okay.
So,
major, okay. When I major.
After completing the 18 years age, that is, you are becoming major.
Yes, okay.
So, the limitation of 3 years for any suit for declaration of title or for cancellation of any document, the limitation under the law of limitation is 3 years.
Okay.
This 3 years will commence from the date when you attained majority. Okay. So 18 plus 3, before your completion of 21st year, you have to file a suit.
Okay. And there is also small.
I will give one relief, one escape.
Okay.
You can file a suit directly without seeking for declaration of title or for cancellation of document. You can maintain a suit directly for recovery of possession.
Okay.
It is governed by Article 62 and Article 61 and 62 of the Limitation Act. So you can file a suit within 12 years after attaining majority.
Okay.
That is, the limitation is long, 12 years from the date of attaining majority. So 18 plus 12. So if you are less than 30 years, still you can maintain a suit for recovery of possession without touching the declaration or cancellation.
Okay, sir.
You
And-
plead the age in that perspective.
Okay, there is also small problem in this.
Sir.
He maintained different schedules, sir, in the other documents. What is the schedule of mine is actual, real
Sir.
one,
Sir.
and he maintained different schedule in the other documents.
Okay.
Is this point will also help me?
Yes, it will definitely help. You can say that your guardian has played fraud on you
Okay.
to keep you in dark without knowing that your property is being sold to some third party.
Yes.
You can plead fraud also. If
Okay.
once you plead fraud specifically, saying that by misdescription of the property, you are kept in dark and you could not understand that your property was the subject matter of sale till now. If fraud is established in this way, you will get a relief, because law is settled that fraud vitiates every solemn contract. Without any further proof of other elements, by showing this fraud itself, the sale deed would be declared vitiated and you would get relief. But
Thank
the
you,
only thing in your case is law of limitation. When your client has attained majority is the question. That has to be.
Okay.
You can maintain a suit within 3 years or within 12 years for recovery of possession. Within this time.
Okay, sir. Thank you, sir.
Welcome, sir. Any other like? Sir Bhaskar Garu,
Sir.
you can raise one any so that we can take further on the discussion by reading the provisions or by reading the Supreme Court judgment, High Court judgment. No purpose would be served. We should have a practical approach.
Sir.
So, when a question is raised in our practice, we all have to discuss on that question and we'll find out some solution.
So somebody has raised their hand, sir.
Yes, sir.
Sir, who is it who raised the hand?
Sir?
Somebody has raised the hand.
Yes, yes, sir.
Bullireddy Golugari. Hello.
Hello.
Bullireddy Garu.
Sir, good morning, sir.
Sir,
Good
Bullireddy
morning.
Garu are not. Yes, sir.
Sir, good morning, sir.
Good morning, Bullireddy Garu.
Sir. Sir, my friend purchased my friend has participated in auction sales, sir, at Kakinada.
A court auction or DRT auction?
Court auction, sir, senior civil judge, sir.
Okay.
And he was the highest bidder in that auction, sir.
Sir.
Court granted is a sir.
Sale was confirmed.
Yes, sir.
Sale was
Sale
confirmed.
sir.
And sale certificate was also issued.
Yes, sir.
Yes, sir.
But MR was not issuing the 1B, sir, Patadar passbook, sir.
What is his objection?
Sir, this attachment in this sir, attachment affected before the sale, sir. After attachment, the plaintiff was sold to another one, sir.
So sale could not be held without attachment. If once attachment was held under Order 21 Rule 54 1A, the terms would be settled, proclamation will be issued, and then only the property would have been sold. So attachment is merged in the sale. The MRO need not have any objection about the attachment. If once sale certificate is there, it is the obligation on the part of the MRO to effect incorporating the change of title in the passbook. If he did not do so, you can file a writ, you can make a representation under the Patadar passbooks and right to Record of Rights Act. You can make a representation under Section 4 of the Act. You can make it within the some 45 days from the date of your sale certificate. You can ask also the MRO to condone the delay, and you can demand, as a matter of right, you can demand the MRO to incorporate the change of title in the Patadar passbook.
Sir, can I say can I ask in Telugu, sir?
Yeah, sure. Bullet గారు మనంతా తెలుగే.
ఓకే సార్. సార్ అది మేము కోర్టు ఆక్షన్ లో తీసుకున్నాం సార్, కాకినాడ సీనియర్ సివిల్ జడ్జ్ సార్.
ఓకే.
అయితే అది అటాచ్మెంట్ ఎఫెక్టెడ్ అయిపోయి ఉన్నది సార్. అయితే ఆఫ్టర్ అటాచ్మెంట్ ప్లేంటిఫ్ వేరే అతనికి సేల్ చేస్తారు సార్. కానీ కోర్టు ఏం చేసిందంటే ఆ సేల్స్ అన్ని క్యాన్సిల్ చేసిందో మరి ఏంటో తెలియదు సార్. కోర్టు మాకు పేపర్లో ప్రకటన ఇచ్చింది సార్, పలానా ఐటమ్ ఇలా అమ్ముతున్నాం కోర్టులో అని చెప్పి.
సార్
అది మేము వెళ్ళాం సార్, హైయెస్ట్ బెడ్రూమ్ అని అయితే ఆక్షన్ కి సేల్ అవుతే మనకి కన్ఫర్మేషన్ ఇచ్చింది సార్.
అటాచ్మెంట్ మీకు చేసినటువంటి సేల్ కు ప్రాపర్టీ కాకుండా ఆ జేడిఆర్ ఆ డిగ్రీ హోల్డర్ కాకుండా సమ్మోర్ డిగ్రీ హోల్డర్స్ కూడా దాన్ని అటాచ్ చేశారు అంటారా?
కాదు సార్, అటాచ్మెంట్ అయిపోయింది కదా సార్, అది
అయిపోయింది.
అయితే ప్లేటిఫ్ ఏం చేశారంటే అటాచ్మెంట్ లో ఉండగానే సేల్ వైలేట్ చేయరు సార్, వేరే వాళ్ళకి సేల్ చేశారు సార్.
అవును,
చేసేస్తే ఇప్పుడు ఎంఆర్ఓని ఏమంటున్నారంటే అది కోర్టు ఆక్షన్ చేసిన ఇచ్చేసిన మాకు అనవసరం, అది మాకు పలానా ప్లేంటిఫ్ అమ్ముడి ఇది ఇప్పుడు సేల్ మాది అని అంటున్నారు.
అటాచ్మెంట్ డస్ నాట్ కన్ఫర్ ఎనీ రైట్. అయితే మీకు సేల్ చేసే నాటికే గనక, నేను తెలుగులోనే చెప్తాను బుల్లెట్ గారు, కోర్టు ఆక్షన్ మీకు అయ్యే లోపలే గనక డిఫెండెంట్ అంటే జడ్జిమెంట్ లెటర్ ఇంకెవరికైనా గనక చేసి ఉంటే డ్యూరింగ్ పెండెన్సీ ఆఫ్ దట్ ఆక్షన్, దట్ ఆ ఆక్షన్ పర్చేజర్ లేకపోతే ఆ అటాచ్మెంట్ పెండింగ్ లో ఉండగా కొనుక్కున్న అతను he would have made an application to raise that attachment and questioning the sale either under Order 21 Rule 89 or under Order 21 Rule 90. ఆ రెండూ చేయలేదు కాబట్టి డ్యూరింగ్ పెండెన్సీ ఆఫ్ అటాచ్మెంట్ చేసినటువంటిది అది వ్యాలిడ్ కాదు. యూ కెన్ మేక్ అన్ అప్లికేషన్ టు ద కోర్ట్ అండర్ Order 21 Rule 94 or 96 అబ్స్ట్రక్షన్ టు అటాచ్మెంట్ రికవరీ ఆఫ్ పొజిషన్ అని చెప్పేసి ఒక అప్లికేషన్ పెట్టండి.
సేమ్ కోర్టా సార్?
సేమ్ ఎగ్జిక్యూటివ్ కోర్ట్ మీకు ఏ సేల్ సర్టిఫికెట్ ఇచ్చిందో అదే కోర్టు దగ్గర మీరు డెలివరీ ఆఫ్ పొజిషన్ కు పెట్టారా ఇంతకి?
సార్ అది ఒకవేళ హైకోర్టులో పెండింగ్ లో ఉండగా మళ్ళీ లోవర్ కోర్టులో సేమ్ Order 94/96 వేసుకోవచ్చా సార్?
హైకోర్టులో ఏం పెండింగ్ లో ఉంది అది చెప్పట్లేదు కదా.
అది రిట్ వేశారు సార్, దాన్ని ఎంఆర్ఓని కూడా పార్టీ కింద యాడ్ చేసి మాకు పొజిషన్ ఇవ్వమని చెప్పి వేసుకున్నాం సార్.
పొజిషన్ హైకోర్టు ఇవ్వదు.
ఓకే సార్.
Order 21 రూల్ 94, 95, 96 అనేటువంటి ప్రొవిజన్స్ కింద ఎగ్జిక్యూటింగ్ కోర్ట్ మాత్రమే మీకు పొజిషన్ ఇస్తుంది బై రిమూవింగ్ ఎనీ అబ్స్ట్రక్షన్. ఆ సమయంలో ఇట్ హ్యాస్ టు డిసైడ్ ది రైట్స్ ఆఫ్ ది థర్డ్ పార్టీస్ యాజ్ ఇఫ్ ఇట్ ఈస్ ఇంక్వైరింగ్ ఇన్ టు టైటిల్ లైక్ ఏ సూట్ అన్నారు. కాబట్టి అందులో ఆ థర్డ్ పార్టీస్ ఎవరున్నారో వాళ్ళ సేల్ వ్యాలిడ్ అవునా కాదా కూడాను ఎగ్జిక్యూటివ్ కోర్టు డిసైడ్ చేసి ఒక ఇది ఇస్తుంది. ది కోర్ట్ కెన్ రికార్డ్ ఏ ఫైండింగ్ దట్ ది సేల్ డ్యూరింగ్ పెండెన్సీ ఆఫ్ ది అటాచ్మెంట్ ఈజ్ నాట్ వ్యాలిడ్ అండ్ ఇట్ కెన్ గివ్ ఏ ఫైండింగ్ దట్ ద కోర్ట్ ఆక్షన్ సేల్ ఈజ్ వ్యాలిడ్. అటువంటి ఫైండింగ్ ఒకటి మీరు యూ కెన్ అబ్టైన్ ఫ్రమ్ ది ఎగ్జిక్యూటివ్ కోర్ట్. అయితే మీరు చెప్తున్న దాని ప్రకారం హైకోర్టులో ఉందంటున్నారు. అసలు ఎగ్జిక్యూషన్ ప్రొసీడింగ్స్ మీద హైకోర్టులో రిట్ ఎట్లా వేశారు
అంటే సార్? అది ఎంఆర్ఓ మాకు 1 week ఇస్తారని చెప్పి మనం వేసుకున్నాం.
సో మీరు ఎంఆర్ఓ గారి మీద ఒక మ్యాండమస్ రిట్ వేసి ఉంటారు.
అవును సార్.
ఫర్ ఏ డైరెక్షన్ టు ద ఎంఆర్ఓ టు ఇంప్లిమెంట్ ది సేల్ సర్టిఫికేట్ ఇష్యూడ్ బై ది కోర్ట్ అని మీరు వేసి ఉంటారు.
అవును సార్.
అంతే కదా?
అంతే.
వేసినప్పుడు సేమ్ మ్యాటర్ ఆర్గ్యూ చేయండి హైకోర్టులో. ఆల్రెడీ వేశారు కాబట్టి
ఆల్రెడీ పెండింగ్ లో ఇప్పుడు ఇక్కడ లోయర్ కోర్టులో వేసుకోవడం కావద్దు సార్.
సార్ అది మీరు లోయర్ కోర్టులో మీరు వేయాల్సింది. నేను మిమ్మల్ని అడిగే ప్రశ్న ఏంటంటే మీకు పొజిషన్ తీసుకున్నారా? సేల్ సర్టిఫికేట్ ఇవ్వడంతో మీకు పొజిషన్ రాదు. You have to remove the JDR or any person claiming through the judgment debtor to have been in possession of the sold property and obtain possession through the process of the court. దానికి Order 21 ప్రొవైడ్ చేసింది. అటువంటి ప్రొసీడింగ్స్ మీరు తీసుకున్నారా పొజిషన్?
తీసుకోలేదు సార్.
అది తీసుకోండి. ఇట్ ఈస్ ఇండిపెండెంట్.
ఓకే సార్.
అసలు మీరు పొజిషనే తీసుకోకుండా how you could apply to the MRO for implementation of the sale certificate. Sale certificate should be followed by obtaining physical possession of the property. So it is independent of the writ proceedings.
ఓకే సార్.
Judgment debtor ఒకటి మాత్రమే పార్టీగా ఉంటాడు, ఆర్ ఎనీ పర్సన్ క్లైమింగ్ త్రూ ద జడ్జిమెంట్ డెటార్ ఉంటాడు. సో ముందు ఆ ప్రొసీడింగ్స్ మీరు ఇనిషియేట్ చేయండి.
ఓకే సార్.
Sir, I can raise a
Thank you.
question, sir.
That's it, sir.
Sir, we do at the moment he said sale certificate, you said civil court or debt recovery tribunal.
అవునండి.
Any sale certificate when issued by debt recovery tribunal is it
No.
different?
I mean, the sales officer of the concerned bank will sell and certificate will be issued, and
Right.
that can be challenged in the DRT.
Right.
Under section 17, I think 17 or 14.
Right. My next question is, sir, whether the sale certificate issued by the recovery officer of a bank can be equated to that of a sale certificate issued by the civil court?
No, for the purpose of enforceability, there are two different aspects. The common feature is a sale certificate either by the bank sale officer or by the court does not confer a valid warranty of title. So a third party's title, which is preceding the title of the judgment debtor or the debtor in a DRT case, surfacing case, will prevail over the title of the title under the sale certificate.
Right.
So warranty of title వచ్చేప్పటికి రెండు ఒకటే. They have no special preference. But DRT వచ్చేటప్పటికి sale certificate can be challenged before the sale officer's certificate can be challenged before the DRT, whereas a sale certificate issued by the court has attained finality and it may be subject matter of the inquiry if possession is resisted by as if it is a suit under Order 21, Rule 94, 95, 96 and 100.
Right.
And now,
Sir, I think we have spent sufficient time.
Yes, sir. But we have
and
only taken only preliminary points. We will continue. We have several cases on amendment of the plaint and written statement. The one question is, if the plaint is amended, what is the limitation? Whether if a third party is added, what is the limitation against that third party? Whether it is from the inception of the suit or from the time when the party is added. So these are some intricate questions of law that has to be integrated. We will take another opportunity to interact with you. I am very much thankful to.
In fact, recently also the Supreme Court judgment which
Yes,
said limitation did not be gone into
At
in
the
the
time of-
amendment of pleading amendment.
Yes, but at the time of amendment, it did not be discussed. But at the time of granting relief,
Good afternoon. Sir, good afternoon, sir.
Sir,
Sir, may I ask one question, sir, if you don't mind?
sir, Narasimha garu, చెప్పండి sir.
Sir, I'm Venkatesh, sir.
Sir, Venkatesh garu.
Sir, namaste, sir.
Namaste,
Sir,
Venkatesh.
thank you for having a great lecture, sir, today. Thank you very much for kind
I
knowledge.
won't claim that it's a great lecture. It is
We
yes.
definitely admitted that this is the good lecture, sir,
No,
actually.
sir.
Thank you.
Sir.
Sir, sir, as far as suit is concerned, sir, section 7 read with section declaration of suit, sir. Declaration of legally wedded wife. There is a rival wives are there, sir. Sir, wives కొట్టుకుంటున్నారు ఒక భర్త యొక్క legitimacy of legally wedded wife.
Sir.
Sir, section 7 of Family Courts Act.
Sir.
So clearly bars that legally any enforceability of legal rights of ni akkada
Between two rival claims as
Yes,
to
sir.
who is as to who is the wife. It
Yes,
cannot
sir.
be simply said that it is a family dispute. It is a dispute how to constitute a family. Who has to be the component of the family? I think it is a civil suit. A decree in rem has to be passed. A decree in rem has to be passed. Who has to be recognized as the legally wedded wife? Because that declaration will have a long time consequences. It will have effect on their children,
Yes,
their
sir.
property rights,
Yes.
and their relations with third parties, and their social status,
Yes.
and a likelihood of stigma attached to the issues of that couple. Therefore, it is a matter to be canvassed by and decided, adjudicated upon by a competent civil court.
So it has to be numbered OS only, not OP.
As OS, as OS.
Why not OP, sir? Because there is a section 7
OP.
bar of Family Courts Act.
Yes, section 7 bars. When section 7 bars, it cannot be a petition before the family court. It is a suit to be filed in a regular civil court. Then it is a original suit. A regular civil court can entertain a petition only if it is under the Hindu Marriage Act, provided a family court is not established for that area. Therefore, it is to be numbered as a original suit only.
If the family court is there, it has to be OP, sir.
No, family court is established. A family court should have a jurisdiction to entertain this suit. When we say that it is not a matter falling within section 7 of the Family Courts Act, automatically section 9 of the CPC would apply, where a civil suit is to be filed. Therefore, it is to be entertained by the civil court as a regular civil suit, as a original suit.
I'll read it for the academic purpose. The prayer which is requested in OS. The plaintiff, therefore, it is prayed that this honorable court may be pleased to grant a decree in favor of plaintiff and against the defendant to declare that the plaintiff is the legally wedded wife of the deceased so and so.
Yes, sir.
So husband ki against ga legally wedded ga wife kan cheppi plaintiff defendants ki against ga inkoka wife in party ga add chesi adigina prayer sir idi.
Yes, sir.
So section 7 lo kuda okkasari of Family Courts Act. Vijayawada jurisdiction, Vijayawada court lo aithe family court is already established, sir. Isn't it, sir?
Whether first నేను మిమ్మల్ని రిక్వెస్ట్ చేసేది అంటే whether a person claiming to the wife, ఇక్కడ plaintiff,
sir,
she is asking for a declaration that she is the wife.
Yes.
So she is not so far as a wife for the purpose of proceeding. She has to be declared as wife.
Okay.
So she is a third party to the family. So it cannot be categorized as a family dispute or a dispute within the members of the family for the purpose of section 7, and therefore it is outside the jurisdiction of a family court.
Oh.
So you have to file it as a suit in the regular civil court.
Okay. I just want to get the clarity from you, sir, so that I am intended to file a rejection of plaint.
Sir.
Because we are for defendants.
This suit is filed for a declaration in the family court.
That's what my contention. Section 7, may I read it for that academic purpose, sir?
You are appealing for the plaintiff, sir?
Defendant, sir, defendant.
You are for the defendant, either husband or the other party who is claimed to be the wife of the defendant.
Yes, sir.
So far as plaintiff is concerned, according to me, according to my view, plaintiff is not a family member. The dispute raised by her is not a dispute concerning the family. She is a third party to the family. And therefore, none of the clauses in section 7 of the Family Courts Act would empower her to approach the family court. Therefore, the suit is barred. The petition is barred.
Okay.
A civil suit has to be filed.
So section 7(1)(e) of Family Courts Act, sir. A suit or proceedings for a declaration as to legitimacy of any person has to be filed in family courts only as a OP.
Yes, legitimacy means legitimacy of the children. Legitimacy of the wife does not arise. A wife is always wife. If not a wife, she must be a concubine.
So for that regard, they have given explanation.
Only the children are categorized as legitimate children and illegitimate children.
So
A person, children alone has to be categorized as legitimate and illegitimate. So a person claiming to be legitimate child, either under section 16 of the Hindu Marriage Act or otherwise, he has to file a suit because admittedly he is claiming to be the offspring of the husband, the father. So he is claiming to be the member either legitimately or illegitimately, member of the family. So a son claiming to be the legitimate son can maintain a suit for declaration in the family court.
Sure.
But if a third party, a lady X, cannot file a suit in the family court to declare that she is the legally wedded wife.
Okay. But will it fall under this, sir? Section 7(1)(b)? I'll read it for that regard academic purpose.
Sir. No. May intervene here.
Yes, sir.
Please raise your questions in one
line.
continuous. అయిపోయిన తర్వాత just it can't go on.
Yes, sir. I'm sorry.
Okay.
May I request you?
Certainly,
not only you.
But certainly, Srinivas Garu, this question is very important question. Whether a wife, any wife.
I'll read it first once again. Section 7, Jurisdiction, sir, Family Courts Act, subsection 1. Subject to the other provisions of this act, a family court shall, అందులో B, sir, be deemed for the purpose of exercising such a jurisdiction under law to be district court or, as the case may be, such subordinate civil court for the area to which the jurisdiction of the family courts extends. అందులో ఎక్స్ప్లెనేషన్ ఇస్తూ బి ఏం చెప్తున్నాడంటే సార్, a suit or proceedings referred in the subsection are suits on the proceedings of the following nature. అందులో a suit or proceedings for a declaration as to the validity of marriage. Sir, validity of marriage కూడా ఉంది సార్.
Validity of marriage is different from, sir, validity of marriage is different from declare that a third party as the wife of the first dependent. Suppose a marriage was performed in Arya Samaj. There is a marriage, but the marriage performed in Arya Samaj is not a Hindu marriage according to the law. But for all practical purposes, she is a wife. There is a marriage. So to declare that the marriage performed in Arya Samaj may be declared as a valid marriage, you can maintain a petition before the family court. But ex claiming to be wife cannot file a petition in the family court to declare that I am the legally wedded wife of so and so. To declare that I am the legitimate wife of so and so.
If she is a legitimate wife of the so and so, then what would be the rival wife of that other person?
That is the reason why a validity of marriage can be decided, but validity of the status of a wife between two rival wives cannot be decided by a family court.
Oh, okay. Anyway, great, sir. Grateful to you, sir. Thank you.
Thank you. Welcome.
Absolutely, indeed, privilege, sir.
Sir.
Good afternoon.
Good morning, sir.
Good morning, sir.
Sir, good afternoon. This is Narsimha, sir.
Sir, చెప్పండి.
Sir, ఇది ancestral property.
Sir.
It is divided into two parts, sir. And one part goes to other brother and the second part goes to another brother. అయితే ఇక్కడ ఏమైందంటే ఈ ఇంకొక బ్రదర్స్ కూడా వాళ్ళ లీగల్ ఎయిర్స్ ఎవరు లేరు అని చెప్పేసి వాళ్ళు ఫ్రాడ్ డాక్యుమెంట్ పెట్టేసి రిజిస్ట్రేషన్ చేయించుకున్నారు సార్. రిజిస్ట్రేషన్ చేసుకున్న తర్వాత దాన్ని ఇమీడియట్లీ ఫైండ్ అవుట్ చేసేసి వి అప్రోచ్ ద కలెక్టర్ అండ్ గాట్ ద ఆర్డర్. దిస్ ఈజ్ ఫ్రాడ్ క్లెయిమ్డ్ అండ్ రివోక్ దేర్ షేర్ అని చెప్పేసి తీసుకున్నాం సార్. కలెక్టర్ ఆర్డర్ ఇచ్చిండు.
కలెక్టర్కి ఏ సంబంధం దీంట్లో ఆర్డర్ ఇవ్వడానికి?
అయితే వాళ్ళు మ్యూచువల్ అండర్స్టాండింగ్ లో వచ్చారు సార్. మా తప్పైందని ఒప్పుకొని
ఇప్పుడు అసలు అంటే ఒక డాక్యుమెంట్ లీగలా ఇల్లీగలా అని చెప్పడం కానీ whether a sale is
As-
legal, civil court చెప్పాలి కానీ how a collector is concerned.
యాక్చువల్ గా యాజ్ పర్ రికార్డ్స్, ఎంఆర్ఓ రికార్డ్స్, వీళ్ళు ఏం చేశారంటే వన్ ఆఫ్ ద బ్రదర్స్ కు లీగల్ ఎయిర్స్ ఎవరు లేరు అని చెప్పేసి వాళ్ళు ఫ్రాడ్ డాక్యుమెంట్స్ సృష్టించేసి ఈ రిమైనింగ్ సెకండ్ షేర్ కూడా వాళ్ళ నేమ్ మీద చేసేసుకున్నారు సార్. అది
ఓకే, రికార్డ్ ఆఫ్ రైట్స్ వాళ్ళ పేరు మీద
ట్రాన్స్ఫర్ చేయించుకున్నారు. ట్రాన్స్ఫర్ చేయించు
to rectify the entries in the record of rights.
ఎంట్రీ అని చెప్పేసి అయితే ఎంఆర్ఓను అప్రోచ్ అయితే ఎంఆర్ఓ ఆల్రెడీ ఎంఆర్ఓనే రికార్డు ట్రాన్స్ఫర్ చేసిండు కాబట్టి ఆయనకు పవర్స్ లేవు. మీరు హయ్యర్ అథారిటీకి వెళ్ళాలంటే కలెక్టర్ దగ్గరికి అప్రోచ్ అయితే కలెక్టర్ వాళ్ళకు నోటీసులు పంపించిన తర్వాత వాళ్ళు యాక్సెప్ట్ చేసారు వాళ్ళ ఫ్రాడ్ అని. చేస్తే ఎంఆర్ఓ ప్రొసీడింగ్ ఇచ్చిండు. ఇట్ ఈస్ యాజ్ పర్ ద కంటెన్షన్ ఈ అగ్రీడ్ ఫర్ ద ఫ్రాడ్ డాక్యుమెంట్ సబ్మిటెడ్ అని చెప్పేసి ఇది ఇచ్చేసి డైరెక్ట్ టు ద ఎంఆర్ఓకు రికార్డ్స్ కరెక్షన్ చేయండి అని రాసేస్తారు.
ఓకే,
బేస్డ్ ఆన్ దట్ ఎంఆర్ఓ కూడా ప్రొసీడింగ్స్ ఇచ్చేసారు. అంటే ఇది రికార్డ్స్ తప్పు, వాళ్ళు ఫ్రాడ్ క్లెయిమ్ చేసుకున్నారు, వీళ్ళకు యాజ్ పర్ దేర్ షేడ్ అని చెప్పేసి ఫిజికల్ ఈ పట్ట పాస్ బుక్స్ కూడా ఇచ్చారు సార్ బిఫోర్ ధరణి. పట్ట పాస్ బుక్లు ఇచ్చేటప్పుడు మాకేం చెప్తున్నారు అని అంటే వీఆర్ కరెక్ట్ ఇన్ ద రికార్డ్స్, మీరు రావాల్సిన అవసరం లేదు, మేము కరెక్ట్ చేసేస్తాం రికార్డ్స్ లో అన్నారు. కాకపోతే అది చేయట్లేదు సార్, అది రికార్డులో చేయట్లేదు. చేయకుండా ఇది కంటిన్యూస్లీ ఆఫ్టర్ దట్ ధరణి కేమ్ ఇంటు ద కోర్స్.
సార్ ఇక్కడ టు బి ఫ్రాంక్ దేర్ ఇస్ ఎ జ్యూరిస్డిక్షనల్ ఎర్రర్. ఒకటి, వాళ్ళు కలెక్టర్ దగ్గర మేము ఫ్రాడ్ చేసామని ఎట్లా ఒప్పుకుంటారు? ఐ డౌట్ అబౌట్ దిస్ అడ్మిషన్.
అంటే అది విలేజ్ లెవెల్లో ఒక మీటింగ్ జరిగింది సార్. అంటే అన్నదమ్ముల పంచాయతీ ఇది, అన్నదమ్ముల పంచాయతీ
అంటే కాంప్రమైజ్ కానీ ఏవైనా సరే కలెక్టర్ గారు ఫర్ వాట్ ఎవర్ ఇట్ మే బి ది డిస్ట్రిక్ట్ కలెక్టర్ యాక్టింగ్ యాజ్ ఎ రివిజన్ అథారిటీ అండర్ ది రికార్డ్ ఆఫ్ రైట్స్ యాక్ట్ హ్యాస్ పాస్డ్ an order directing the MRO to rectify the entries in the record of rights. That was not done by the MRO. You again make an application to the collector to give another direction or file a writ to give direction to the revenue authorities to implement the order of the collector. కలెక్టర్ గారికి ఇంకోసారి రిమైండర్ ఇవ్వండి, మీరు ఇచ్చిన ఆర్డర్ మీ సబార్డినేట్ ఇంప్లిమెంట్ చేయట్లేదు, ఇన్సబార్డినేషన్ అని ఒక రిప్రజెంటేషన్ ఇవ్వండి. ఇఫ్ ద కలెక్టర్ డిడ్ నాట్ మూవ్ ఆన్ దట్, యూ ఫైల్ ఎ రిట్ ఇన్ ద హైకోర్ట్ డైరెక్టింగ్ ద రెవెన్యూ అథారిటీస్ టు ఇంప్లిమెంట్ ది డైరెక్షన్స్ ఆఫ్ ది కలెక్టర్ అండ్ ఇన్కార్పొరేట్ ద చేంజెస్ ఇన్ ద రెవెన్యూ రికార్డ్స్. That is sufficient.
So,
sir, Chairman, sir.
Sir,
good afternoon, sir.
I am Prabhakar. Practicing. Yes, sir. I am Prabhakar, practicing advocate in Supreme Court, sir.
Oh, very nice, Prabhakar.
Sir, it is very pleasure and privilege to have and to talk to you. I had no occasion when you were in Supreme Court as a Secretary General. I could not meet you, sir.
Sir.
Very nice to see you.
Thank you, sir.
See, sir, your lecture is very much useful. The way you have encapsulated the things are very practicable and which is very much useful. People like me who have started directly practice in the Supreme Court.
Sir,
without
great
having any practical knowledge before the trial court. I started my practice in a Supreme Court. It's very much useful to me, sir.
Thank you, sir.
I'm very much thankful to you.
Thank you, sir.
Thank you so much.
Thank you, sir.
He was waiting to give that thanks message.
Prabhakar garu, very nice to sir. Very nice to see.
He belongs
Thank
to
you, sir.
Andhra Pradesh.
Yes, ma'am. I met you also.
అవును.
Sir, good evening. Sir, good afternoon, sir.
Sir, good afternoon, sir.
Sir, ఒక సర్వీస్ మ్యాటర్ ఉన్నది సార్. ఏంటంటే ఇక్కడ మా ఏరియాలో ఒక ఆంటీ ఏం చేశారంటే మెడికల్ అయితే కోర్టులోనే పనిచేస్తున్నారు యాజ్ ఎ జూనియర్ అసిస్టెంట్ గా. అయితే కోర్టు నుంచి మన వాళ్ళ డిస్ట్రిక్ట్ కోర్ట్ కి లెటర్ పెట్టారు, సో అండ్ సో ఐఎమ్ ఇల్ హెల్త్, దాన్ని బట్టి నాకు కంపాషనేట్ అపాయింట్మెంట్ ఇవ్వండి మా కొడుకుకి అని పెట్టారు. పెట్టిన తర్వాత వాళ్ళు ఏం చేశారంటే మెడికల్ బోర్డ్ కి రిఫర్ చేశారు. అయితే మెడికల్ బోర్డ్ నుంచి ఏమొచ్చింది, అన్ఫిట్ వచ్చింది. నిమ్స్ అనేది పెద్ద మెడికల్ బోర్డు ఉన్నది హైదరాబాద్ లో సార్. అక్కడ నుంచి షీఈస్ అన్ఫిట్ ఫర్ కంటిన్యూ ఎంప్లాయ్మెంట్ అని వచ్చింది. వచ్చిన తర్వాత మళ్ళీ అప్పుడు ఆ లెటర్ వచ్చే వరకు వేరే అడ్మినిస్ట్రేటివ్ ఆఫీసర్ వేరే జడ్జ్ వస్తే వాళ్ళు ఏం చేసిర్రు అంటే ఆ రిక్వెస్ట్ ని రిజెక్ట్ చేసిర్రు. ఎందుకు రిజెక్ట్ చేసిర్రు అంటే ఆ డిసీజ్ అనేది వాళ్ళు డిసీజ్ ఏదైతే మెన్షన్ చేశారో ఆ జియోలో లేదు అని రిజెక్ట్ చేసిర్రు అప్లికేషన్. అయితే ఇప్పుడు మనం అయితే ఆ ఆంటీ అనేది మళ్ళీ ఇక ఇప్పుడు రిజెక్ట్ చేసిర్రు కదా ఇప్పుడు కాదు అని మొన్న మార్చ్ లో రిటైర్మెంట్ పెట్టేశారు, విఆర్ఎస్ తీసుకున్నారు. అయితే ఇప్పుడు మనం దాన్ని ఛాలెంజ్ చేయొచ్చా సార్ హైకోర్టులో కానీ ఎట్లా?
సార్ ఒకటి రెండండి, ఇదేమో ఇవాళ మన టాపిక్ సంబంధించింది కాదు. ఐఎమ్ నాట్ ప్రిపేర్డ్ ఫర్ ఇట్. ఐఎమ్ నాట్ ఎక్స్పర్ట్ ఆన్ సర్వీస్ మ్యాటర్.
Aziz, call us after the session.
Okay, that is what we are requesting you all.
Okay.
Kindly confine your questions only to the pleadings. And
unfortunately, pleadings are everywhere. Pleadings are connected to each topic. That's why people are very curious to ask how to plead in their situation.
Okay, sir. I can give one simple answer. Giving an employment on compassionate ground is only discretion of the employer and the government. It is a policy decision. The court cannot enforce that policy decision should be invariably followed by the employer. That is the settled law. Rendodi, ఏ గ్రౌండ్స్ మీద కంపాషనేట్ అపాయింట్మెంట్ ఇవ్వచ్చు అనేది ఒక జీవోలో మెన్షన్ చేశారు కాబట్టి ది కోర్ట్ కెనాట్ గివ్ ఎ డైరెక్షన్ టు ద గవర్నమెంట్ ఆర్ ఎంప్లాయర్ టు ఇంక్లూడ్ అనదర్ కేటగిరీ ఆల్సో ఇన్ దట్ జీవో. That is interfering with the policy decision of the government, which is not open to the court. If your fundamental rights by refusal of such employment is affected, you can file a writ. But compelling the government to provide employment to you is not a fundamental right. So it is a fluid question that cannot be hypothetically decided.
In fact, in one of the judgments, it was held that compassionate appointment is violation of Article 14.
If it falls within the categories of the clauses in that GO, then it is a fundamental right. Now they say that disease is not in the category. Therefore, whether we can enforce that category also to be included in the list of categories for compassionate appointment, so that may not be possible.
It seems one session is not enough for your lecture, sir.
No, I will take another.
No, sir. In fact, I was emboldened to say, sir. He said we'll deal with other session. So that means sir is coming for other sessions also.
Okay, sir.
Coming soon.
If possible, we will hold another session.
Right.
Let me take that opportunity also. I am very much privileged by the invitation extended by Yagna people, and I congratulate them for organizing this webinar very successfully.
Thank you so much, sir, for the kind lecture, sir. We are very thankful to you, sir. And with this, we are concluding today's webinar. And on behalf of Egna Legal and on behalf of the participants, I thank you, Avadhani Garu, and we are expecting your blessings in the future course also, sir.
Definitely, sir. I am very grateful to every one of the participants and mostly to Yagna, Mr. Bhaskar, my longtime friend, and Mrs. Sridevi. I wish you all success in your future endeavors also. Thank you.
Thank you, sir.